Hello, everyone, and welcome to Uncivil Law. For today, we are doing a story by request of one of our members who donated $20 for me to cover the concurring opinion by Justice Thomas in the case of McDonald versus City of Chicago. This is the case that incorporated gun rights against the states. It was the follow-on case to Heller. Heller decided there were gun rights, but it was in D.C. deliberately to establish it against the federal government. Then the follow-on case, McDonald, was saying, well, is it applicable to the states? The answer was yes. And so the majority opinion does this under substantive due process and incorporation doctrine, which is how all these things have been done. Justice Thomas, on the other hand, is not a fan of this. He wants to do it under the Privileges or Immunities Clause of Section 1 of the 14th Amendment, which is probably more intellectually pure. We're going to read some of his opinion and what he has to say about it, some of his description of how we got here. It's really interesting as a look at originalist thinking and how some of this is being done in terms of looking at things and trying to interpret language in an originalist way. So let's get started with this. Justice Thomas writes, I agree with the court that the 14th Amendment makes the right to keep and bear arms set forth in the Second Amendment fully applicable to the states. I write separately because I believe there is a more straightforward path to this conclusion, one that's more faithful to the 14th Amendment's text and history. Applying what is now a well-settled test, the plurality opinion concludes the right to keep and bear arms applies to the states through the 14th Amendment's Due Process Clause because it is fundamental to the American scheme of ordered liberty. I agree with that description of the right, but I cannot agree its enforcement against the states through a clause that speaks only to process. Instead, the right to keep and bear arms is a privilege of American citizenship that applies to the states through the 14th Amendment, which is Privileges or Immunities Clause. So as he's going to get into in a little bit of depth, the way that you typically have done this in American law is the Supreme Court essentially created a theory called substantive due process. So what is that? The 14th Amendment says in text that no person can be deprived of life, liberty, or property without due process of law. The text on its face speaks to procedure, right? You can't be deprived of this without this, right? So that's a procedural thing. But the Supreme Court has said that there's some sort of life, liberty, or property interests that are so fundamental that no amount of process can withdraw them. And that's substantive due process. Now, to me and Justice Thomas, that doesn't make sense because the text says you can. It says so right in the text. You can't be deprived of life, liberty, or property except with due process, which means you can be deprived of it with due process. Procedure. So the idea that there's a substantive element built into this text is really weird. And the reason this was done was to solve a problem from the Supreme Court because they misinterpreted it in an earlier case. So they basically had one of two choices: undo the earlier case, which was mistaken, or sidestep the issue by creating an entirely separate theory, which is not really bound in the text. And they went with option 2. And Justice Thomas and I are both a little bit irritated by this because we have a perfectly good serviceable thing in the first clause that says exactly what we need to say. Why are we doing this in the second clause? Why don't we just bring back the first clause? It's right there in the text and we wouldn't be having this discussion. But, that's what we've been doing for, 80 years or whatever. So that's where we are basically, is your too long didn't watch summary. For those of you who are not watching the rest of this video, I have now summarized the history of this, but we're going to go into depth for those of you who want to learn more about it. So how did the 14th Amendment come to be and what does it mean? Always a good place to start, right? After the Civil War, a series of constitutional amendments were adopted to repair the nation from the damage slavery had caused. The provision at issue here, Section 1 of the 14th Amendment, significantly altered our system of government. The first sentence of that section provides that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state in which they reside. This unambiguously overruled this court's contra holding in Dred Scott versus Sanford that the Constitution did not recognize Black Americans as citizens of the United States or their own state. So this is not the first time that we have done this, incidentally. The 11th Amendment was also written specifically to overrule a U.S. Supreme Court case. So it's not the first time we've done this, right? So we said, well, Dred Scott was wrong, and we're going to overrule that by passing a constitutional amendment that says it's wrong. This is a very good way to change constitutional law, all right? Let's pass an amendment that overturns it. Excellent. So, the pre-Civil War case law that said African-American blacks are not citizens of the United States, we think that's wrong. So let's create a law that makes it clear that they are citizens. All persons born or naturalized in the United States are citizens of the United States. That's race neutral, that's gender neutral, it's everything neutral. Are you born in the United States? You're a citizen. So that solves that problem. Excellent. We have fixed the problem through a constitutional amendment. Great. The meaning of Section 1's next sentence has divided this court for many years. That sentence begins with the command that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. That sounds pretty clear to me and Justice Thomas. It's like, why do we need to create this whole substantive due process theory? We have text that is doing what we need to do. It's right here. So, we could just read it and do that. That'd be good. Yeah, okay. On its face, this appears to grant a person just made a United States citizen, that would be the black people that were previously being deprived of that status, because white people had United States citizenship. It was just black people who didn't, and now we want them to have citizenship too. Good idea. So on its face, this grants these people, who we just made citizens, a certain collection of rights. The privileges or immunities attributable to the status of being citizens. So white people had rights. We now want to give all the people rights. Excellent. Let's do that. This court's precedence accepts that point, but narrowly defines the relevant collection of rights. Yeah, this is where it went off the rails. So we're going to learn a little bit of where it went off the rails. Is your constitutional history of where things went wrong. In the Slaughterhouse cases, which I've spoken about obliquely and in passing as one of the cases I don't like for specifically this reason, in the Slaughterhouse cases, decided just 5 years after the 14th Amendment's adoption, the court interpreted this text, now known as the Privileges or Immunities Clause, for the first time. In a closely divided decision, the court drew a sharp distinction between privileges and immunities of state citizenship and those of federal citizenship. Okay. And held the Privileges or Immunities Clause protected only the latter category of rights from state abridgment. Okay, so they're saying there's a difference between rights that would come from state citizenship and federal citizenship, and the Privileges or Immunities Clause only protects those that are coming from federal citizenship. Which, at least on its surface, I'm probably okay with that, because that makes sense. Because the federal Constitution, right? The federal Constitution, or Bill of Rights, more specifically, the Bill of Rights only initially applied against the federal government, right? So it would only protect you against federal government action. So it makes sense to say, the Bill of Rights are rights that exist as part of federal citizenship, because they're things because we have this whole dual sovereign doctrine. Because we have a federalist system, so we have to go way back into federalism land, right? So we'll go back and talk a little bit about federalism again as we explain this, so we can understand it completely, right? Okay, so we have a federalist system. We have a collection of independent nation states that are in a combined federal government, okay? So they're in a collection as a federal government, all right? And this can exist on a continuum, right? This can exist from a very loose relationship that might be indicative of the Articles of Confederation or the European Union, where the individual nation states are independently sovereign. The national government, as such, the national EU, doesn't really have sovereignty. We don't think about it in those terms, and there's no real things. So it doesn't really make sense, right? So there's on that continuum where these individual nation states are still independent and operating independently with some sort of loose common connection, which might be indicative of any treaty, any treaty would be this, right? There's two nation states agreeing in collaboration with some sort of common framework above them, right? That's any treaty. And then we have some sort of loose affiliation like the EU or the Confederated States as it existed in the pre-constitutional era when we had the Articles of Confederation. Loose confederation, independent nation states with a weak federal government, right? And then you can go even further on the continuum. You can go so far on the continuum that at some point they are no longer independent nation states in any sense of the word. They're just constituents of a common federal government. So they've lost their sovereignty. So you can go that far, right? And say, well, at some point the countries have merged. That happened in history lots of times. I don't need to point out examples of where that happened for all kinds of reasons. Two independent countries have merged through one reason or another. They're no longer independent, right? And even if you recognize them to some degree separately, they are no longer independent entities. They are now part of one combined whole, right? So it can be anywhere on this continuum of stuff, right? All right. So the U.S. system exists somewhere in the middle of this, as you might expect. It exists more connected than an average treaty, more connected than the EU, more connected than the Articles of Confederation, but less connected than they are no longer independently recognizable. So it's somewhere in between those two things. That's federalism, right? So in the U.S. system, we talk about sovereignty as both the state, being like the state of South Carolina, the state of Florida, the state of Texas, the state of whatever. We talk about that level of sovereignty. And we also talk about federal government sovereignty. They're both sovereign at the same time. Their elements of sovereignty are different, right? Because the way that we've solved this problem is they have different domains of sovereignty, right? So the federal government has some limited domains of sovereignty, and all the rest is state sovereignty. So especially, one of the ways that this is put in the Supreme Court language is that you split the atom of sovereignty. That's one of the ways they put it in the language, which is basically, correct. Because the word atom, as you might remember, means indivisible in the original Greek. But we've divided the indivisible. We have split it into two constituent parts. And so they're both sovereign now to different levels and different degrees. They're not sovereign in the same way. Their powers are different. They have different levels. They have different things. One can do stuff the others can't do, and that goes both ways. So it's not like the federal government has necessarily more power. It depends on what you're talking about. The state government has a lot more power, particularly as it comes to criminal law. They have a lot more power. Or land rights, they have a lot more power. So there's a lot of elements in which the states are more powerful than the federal government. The federal government's powers are mostly, but not exclusively, international focused. So if you want the quick and dirty difference, the states are mostly internally focused, and the federal government is mostly externally focused. So only the United States federal government can go to war. Only the United States federal government can sign treaties. Only the United States federal government can do international diplomacy. It's outward looking. And the states are mostly inward looking. Only the individual state can do certain things that they can do. So that's how we've solved that problem, right? All right. So now we have a concept of okay, what are you a citizen of? Well, in the same exact way that we have this dual sovereignty doctrine, you can be a citizen of two things at the exact same time. You have a federal citizenship and a state citizenship. You have them both at the same time. The 14th Amendment reflects that. You're a citizen of both at the exact same time. So it's correct to say you're a citizen of the United States and a citizen of any particular state that you live in. And incidentally, one of the ways that you know that you're a citizen of a state is because you can vote there. That's what it means. One of the things that comes with citizenship, right? If you're not a citizen, you can't vote. That's a good example. If you're not a citizen, you can't serve on a jury. If you're not a citizen, there's perks that comes with citizenship. And so, one of the reasons that you're a citizen of a particular state and not other states is that you can do certain things in that state that you can't do in other states. Right? So you have two different kinds of independent citizenship. And they both can change and operate independently. So the 14th Amendment is designed to reflect this. It's designed to reflect that you're a citizen of the United States and your state to different degrees. And it is correct to say you're a citizen of both because both have powers and both are sovereign, and federalism, and it's complicated. But that's what they're talking about here, right? Hopefully some of that made sense. So that's what they're talking about in this part of the opinion. They're trying to determine this privileges or immunities clause, what parts of what citizenship rights are it extending, right? So it talks about privileges or immunities. What are those? And we'll get into it later that essentially means the same thing as rights. It's just alternate language for rights, which makes sense to me. It's just an alternate way to use the word rights. So it's well, what rights are those? So we have a couple options. They could be the rights of the federal government. They could be the rights of the state government, or presumably they could be both, right? So it could be referring to one or the other or both. Which of those options is it? So this Supreme Court, well, the Slaughterhouse case Supreme Court said it's referring to the parts that are federal in nature. It's imposing on the states the federal rights that come with federal citizenship. That makes sense because the Bill of Rights was talking about federal things. They only applied against the federal government. So to the extent you're a federal citizen, you couldn't be deprived of, freedom of speech, for example. But to the extent you were a state citizen, you could be. That's where things get complicated in federalism land, right? Because you're talking two different contexts at the exact same time. So the 14th Amendment is trying to solve that problem. It's saying, okay, all the rights you have as a federal citizen now apply to all the states. So all the federal rights, all the federal citizenship stuff you had, now applies to states. No states shall abridge the privileges or immunities of the United States. Okay, this I understand. And if we talk privileges or immunities, what does that mean? It means the same thing as rights, Bill of Rights. Great. No problem. I got this. It's fine. So I'm just going to take the entire Bill of Rights, say that they're part of a federal citizenship right, which seems right, because they applied to federal citizens, white people, before the Civil War. So I'm going to take all that stuff and say all that stuff that was part of your United States rights from like before this clause, and we're not creating new rights. We're not even creating new kinds of citizens. United States citizens existed before this. We're defining the class of people that it applies to. All that stuff now applies against state actors too. Okay. And so they're saying it's the federal rights and not the state rights, which makes total sense. I'm totally on board with it. It wouldn't make sense the other way around. It wouldn't make sense the other way around to say it's referring to the rights of states, the ones that were just abridging your rights, like, just before the Civil War. Why would the federal government's constitution guarantee the rights provided by the individual states, which, about 5 seconds ago, relative to the time period we're talking about, were, depriving people of rights? Why would it do that? It doesn't make any sense. It must be the federal rights. So that makes total sense. I'm totally on board with that part of it. Okay, great. Okay, good. I'm fine. So the court declined to define that category to include only the rights which owe their existence to the federal government's national character, its constitution, or its laws. Which, again, the entirety of the Bill of Rights. I'm on board. Bing, bang, bong, done. Done in one. No problem. All right, but the court didn't go that way. The court didn't go that way, which created the problem. This arguably left open the possibility that certain individual rights enumerated in the Constitution could be considered privileges or immunities, presumably the entirety of the Bill of Rights, right? But the court soon rejected that proposition, interpreting the privileges or immunities even more narrowly in its later cases. So yeah, that's a problem. That's where things are going off the rails, is when it's being narrowed down. Your rights of federal citizenship are actually much narrower than you ever thought. No. Chief amongst these cases is United States versus Crushank, which, has the virtue of being a Second Amendment case. So that's nice. This is where they really screw it up, right? There, the court held that members of the white militia who had brutally murdered as many as 165 black Louisiana congregants outside a courthouse and not deprived the victims of privileges or immunities as American citizens to peacefully assemble or keep and bear arms. Well, presumably whatever it means by white militia, what exactly do we mean by white militia? Because that may or may not come out the same way, because it would depend on whether or not it's state action. So it's a little unclear when they're talking about white militia, what exactly do we mean? Because, we would still say that, private actors don't deprive people of rights, only state actors. So it's a little unclear if what that means in that context, whether that would come out the same way for different reasons. According to the court, the right to peacefully assemble codified in the First Amendment was not a privilege of the United States citizenship because the right existed long before the adoption of the Constitution. No, that doesn't make any sense. No, that's where it goes way off the rails for me. No, that's where I'm like, no, absolutely not. No. Yes, the right pre-existed the existence of the Constitution, because the Constitution talks about the freedom of speech. The way that we've interpreted that classically is the pre-existing freedom of speech. The First Amendment is not creating a right. It is recognizing a pre-existing right. So the court is right that it's a pre-existing right that precedes the First Amendment. That's certainly true. No one denies this. And, it's recognizing a pre-existing right. But to say it's not a right of federal citizenship because the federal government didn't create it, that makes no sense. Like, one of the entire points of the Bill of Rights was specifically to codify particular rights as being essential to being an American. So whether or not the federal government is creating them or not, it's part of the deal. So you're saying, it's not a privilege or immunity because it wasn't created by the federal government. It was only recognized by the federal government. This is madness, man. This is madness. This is where I get well off board here. Similarly, the court held the right to keep and bear arms was not a privilege of the United States because it was not in any manner dependent upon the instrument for its existence. Again, it's talking about recognizing a pre-existing right? The right to keep and bear arms, what is it? It's the pre-existing right that existed before, the one in common law that's existed through, many, many, many years of interpretation. It's a pre-existing right, the one that already existed. It's not creating it, simply recognizing it. The freedom of speech, the right to bear arms. The word "the" here is a definite article. It's a definite article, right? As opposed to, it's the difference between a apple and the apple. A apple means any apple. The apple is a particular apple, right? Because it's a definite article. It refers to an antecedent, right? It refers to something else. So the freedom of speech, the right to bear arms. It's the pre-existing right. And so its contours and definitions are defined as they existed before. So all the people who want to talk about what the right to keep and bear arms may be, at least as far as I'm concerned, you have to talk about what it meant, in the antiquity, because that's exactly what it's talking about. So but the federal government is recognizing it. So this doesn't flow at all for me. This is no. This is where I'm departing with the prior Supreme Court and agreeing with Thomas. It's this doesn't make any sense. In other words, the reasons for framers codify the right to bear arms in the Second Amendment, its nature as an inalienable right that preexisted the Constitution's adoptions, was the very reason citizens could not enforce it. And that's that doesn't make any sense. I'm with Thomas. It doesn't make any sense. That circular reasoning effectively has become the court's last word on the Privileges or Immunities Clause. Yeah, because it is completely broken. And when it came around to trying to figure out a way to adopt the Bill of Rights, they could have just overruled this case. But they tried to go around it by inventing an entirely separate theory of rights. It's why bother? But that's what they did. In the intervening years, that would be the intervening years since this Croshank decision and today, the last 140 years, that'd be the intervening years. The court has held the clause prevents state abridgment of only a handful of rights, such as the right to travel, that are not readily described as essential to liberty. It's it's why do this? Why go through all this effort? So it's yes, you have a right to move around from state to state. And then, of course, every sovereign citizen everywhere says, I have the right to travel. That means I can drive a car as long as I say I'm traveling. No, not so much. No. No. But, thank you for playing. No. You do have a right to travel. The means of travel are not guaranteed. So, you certainly have the rights. You definitely have the means, as far as I'm concerned, that you did in what was the year of the 14th Amendment? 1868? Did I get that year right? So you have the same rights to travel that you did in 1868, as far as I'm concerned, which, is horse and walking. But, go nuts. It's fine. If you're riding a horse, and a cop pulls you over and says, where's your license? We'll talk. In terms of right to travel. You might have a right to travel case there. Not for the car. No. As a consequence of this court's marginalization of this clause, litigants seeking federal protection of the fundamental rights turn to the remainder of Section 1 in search for an alternative. Yeah, they're trying to find a thing to do exactly what this section was written to do. It was written to do exactly this. And the Supreme Court, having kind of nuked it, everyone's like, oh, how do we bring this back? Because it was the entire point. They found one in the most curious place. The sections command that every state guarantee due process to any person before depriving of life, liberty, or property. At first, litigants argued that due process clause incorporated certain provisional rights in the Bill of Rights, and the court generally rejected those at first. And in the process of incorporating these rights against the states, the courts often applied them differently against the states than the federal government on the theory that only those fundamental applied. So yeah, when they were first doing this, there were some false starts. It's a pretty good way to put it, right? There were some false starts where there's like a little bit of like not applying them fairly, a little bit of like, just doing it double way. They're a little bit inconsistent at first. Yeah, okay. Maybe because they were trying to do it through language that they were essentially inventing out of nowhere, to fix a problem that they created. In more recent years, this court has abandoned the notion that the guarantees in the Bill of Rights apply differently when incorporated against the states than they do in the federal government, and thank God for that. But our cases continue to adhere to the view that right is incorporated through due process clause only if it's sufficiently fundamental, a term the court has long struggled to define. Yeah, fair enough. And that's one of the reasons that the grand jury clause has not been incorporated, because it's not deemed fundamental. Which, whatever. I mean, I don't have a particularly strong view. I don't know. I don't think having grand juries would really do anything for anybody, to be quite honest. They're a little rubber stampy. They really are not doing anything for anyone. So, I don't know it would matter, because, who cares a little bit, but yeah. So, at this point in history, by, today, at this point in history, it's if we actually went through the exercise of saying, well, we've been wrong all this time about substantive due process, what we actually meant was privileges or immunities, it's a little unclear it would come out any differently. Because we basically incorporated everything. There's not much left. The Third Amendment hasn't been incorporated because, not a lot of quartering of troops, and there's, I think, one or two other ones that haven't been incorporated, but there's not much left. So, there's not much reason at this point to undo all this case law, to do it under Privileges or Immunities Clause, because we'd effectively be in exactly the same place. It'd be more intellectually pure and be more on text. But as a practical matter, I'm not sure it would matter either way at this point. But that's how we got where we are, because of all this convolutions. We created this convoluted thing to fix a problem that shouldn't have existed in the first place. So Justice Thomas is pointing this out, and rightly so. And Justice Thomas says all this is a legal fiction. It sure is, because it's unmoored to anything. Yeah, it's a legal fiction. The notion that Constitution provisions that guarantee only process before a person is deprived of life, liberty, and property could define the substance of those rights strains credulity for even the most casual users of words. I don't disagree. Moreover, this fiction is particularly dangerous. The one theme that links the court's substantive due process precedents together is their lack of a guiding principle to distinguish fundamental rights that warrant protection from non-fundamental rights that do. Today's decision illustrates the point, replaying a debate that has endured from the inception of the substantive due process guarantee. The dissent lauds the flexibility in this court's substantive due process. That is one problem. But again, it's a little bit of a mooted problem at this point. Because by doing this piecemeal, by doing this one thing at a time, every time it's had to be incorporated. And again, every clause has had to, there's a case somewhere for every single clause in the Bill of Rights that is incorporating it or not, but mostly four, right? So there's a clause every single time that's doing it. Individually, one at a time, pain in the ass. And, he's pointing out that every single time it's a gamble, because every single time the court could theoretically say no. Whereas with the Privileges or Immunities Clause, you don't have that problem, because it's a one and done. It's a one and done. It just adopts the whole Bill of Rights, end of case. Rather than having to risk this game every time, where every time it's like, well, is it fundamental or not? Now, again, at this point, as a practical matter, I'm not sure how much difference it would make, because there's not much left that's not incorporated, and, but, he's right, it was a gamble every time. The plurality makes yet another effort to impose principled restraints on the exercise of this, but neither side argues the meaning they attribute to the due process clause was consistent with understanding at the time of ratification. So yeah, neither side is saying this is originalist. One side is saying we should do it and one side's not. And neither side is saying, but this is what they originally meant, though. So Justice Thomas is being more pure than anyone on originalism, which he is, by far. He's very pure in his thinking, which, it's to be lauded. It's to be lauded. He's saying something that's fundamentally true. The Supreme Court made a mistake 140 years ago and has been building on that mistake for the last 140 years. And, you've wound up in a place that is like practically the same, but it doesn't make any intellectual sense. And he's saying, well, here's a way to do it that makes more intellectual sense. And I'm like, yeah, Justice Thomas is right. Now a pragmatic concern, and Justice Thomas is not a pragmatist, right? So he wouldn't raise this concern, but I might, because I'm not as pure as Justice Thomas. I'm originalist, but not this pure, and I'll openly admit that. I admit my limitations. So, like, one of the concerns that would run through my mind is, what's the point? It's a pragmatic point. What is the pragmatic point of doing it? It's more intellectually pure, but what's the point? Because it would come out the same way either way. So why go through all the effort, right? So let's maintain the fiction because it's just as good as the reality. So, I'm not as pure as Thomas. So I'd ask that question, Thomas wouldn't. But, that's where I am and that's where he is. Fair enough. To be sure, the plurality's efforts to cabin the exercise of discretion under due process by focusing its inquiry on those rights deeply rooted in American history and tradition invites less opportunity for abuse than the alternatives. But any serious argument over the scope must acknowledge that neither its text nor history suggests that it protects many substantive rights as courts claim it does. Yeah, that's where we've built it on we've built this entire thing on a mirage. That's true. Thomas continues, I cannot accept a theory of constitutional interpretation that rests on such a tenuous footing. This court's substantive due process framework fails to account for both the text of the 14th Amendment and the history that led to its adoption, filling in the gap with jurisprudence devoid of a guiding principle. That's true. It's a problem. I believe the original meaning of the 14th Amendment offers a superior alternative. It clearly does. And that return to that meaning would allow this court to enforce the 14th Amendment is designed to protect with greater clarity and predictability that the substantive due process framework has so far managed. Yeah. This thing we've cobbled together is a little bit, bits and pieces when we could just, go to this other thing, which has a lot more substantive. I understand this completely. It cannot be presumed that any clause in the Constitution is intended to be without effect, because the court's privileges or immunities precedents have presumed that. Apparently, yes. I set them aside for the moment and begin with the text. Always a good place to start for an originalist, right? The Privileges or Immunities Clause states that no state shall abridge the privileges or immunities of citizens of the United States. Interpreting that language, it's important to recall the constitutional provisions are written to be understood by voters, the meaning at the time. Okay? Thus, the objective inquiry is to discern what ordinary citizens at the time of ratification would have understood privileges or immunities clause to mean. I don't quite agree with that. Because the people that are ratifying this, or of course the state legislatures, they're the ones that are ratifying. Now they're doing it on behalf of citizens, and citizens are the ultimate justification for the good force of law. But I don't quite agree that the right frame is the average common citizen. Not for least of reasons that at this point of history, right? Education and communication and all the rest is a little bit flaky as compared to today. So I would probably say I'd be more reliant on what the legislatures understood of the collective states, the people who wrote it. Because it's a constitutional amendment, I'd be looking both to the legislatures of the Congress and the legislatures of each respective state, because they're all acting collectively for this thing. So that would be my target. What are they collectively thinking, rather than the average person? I'm not sure how much that matters between me and Justice Thomas, but I think it's probably more accurate. At the time of Reconstruction, the term privileges and immunities had an established meaning as synonyms for rights. So he says it means the same thing as rights. Cool. No problem. Language changes over time. There's other examples in the Constitution as this. So they use the phrase privileges or immunities to mean exactly the same thing as rights. Cool. I'm on board with that. The two words standing alone or paired together were used interchangeably with the word rights. So there's no difference between privileges or immunities. They mean the same. They're exactly synonyms for each other. So separately or together, they mean the same thing. Okay, fine. That's fine. That's cool. Citing Blackstone. Okay, a number of antebellum judicial decisions have used this term in this manner. Great. In addition, the dictionaries at the time confirmed this public shared this understanding. Okay, great. I'm fine. That's fine. The group of right bearers to whom the Privileges or Immunities Clause applied is, of course, citizens. By the time of Reconstruction, it had long been established that both the states and federal government existed to preserve their citizens' inalienable rights, because, again, you're a citizen of both, because of federalism, dual sovereignty, dual citizenship, blah, blah, blah. We may have the most complicated form of government anywhere in the world. I don't know enough about the UK to know how theirs compares. Because, yeah, I'm not, are they is the UK more or less integrated than the US? That's an interesting question. I'm not sure. But we're somewhere close to that. Is the only other example in the world where it's like at least a reasonably close example. But yeah, the whole thing is a little weird in the UK. I'm not even going to begin to analyze the difference between the two. This tradition begins with our country's English roots. Of course it does. Parliament declared the basic liberties of English citizens in a series of documents ranging from the Magna Carta to the Petition of Rights and the English Bill of Rights. It's the pre-existing right. So we're looking to these things that pre-existed to help us, right? These fundamental rights belong to all people, but became legally enforceable only when recognized in legal texts, including acts of Parliament and decisions of common law judges. Fine. The rights included many of those later that would be set forth in our Bill of Rights, such as the right to petition for the redress of grievances, the right to a jury trial, and the right of Protestants to have arms in their defense. Right. So our Bill of Rights is borrowing, hijacking from the English Bill of Rights and English common law, Magna Carta, and all the rest of it, right? It's the freedom of speech, the right to bear in arms. It's the pre-existing one. What is that? Well, go look to the English law. And that's what we're adopting it from. We're like yoink, we'll have some of that. So yeah, that's basically what it's talking about. And so to understand what it is, you look to all those documents to figure out what the heck they're talking about. And that makes sense because especially to a legislator, right, who's using this term, right, they are understanding it in light of all the case law, because that's how we think in the common law system, which us in the UK share, right? So they're thinking in terms of that case law. So they're writing it with the understanding of all that background in mind. So when they write the right to keep and bear arms, they are thinking, presumably, in their head about all that stuff. So that's what they're talking about. All that stuff. All the stuff that is. That's what we're talking about. The right to keep and bear arms is what? That's 5 words. The right to keep and bear arms. 7 words. So yeah, those 7 words are carrying a lot of weight. Those 7 words are carrying a lot of weight. They're basically incorporating by reference all the stuff. So those 7 words are doing a lot of weightlifting, yeah. The text examined so far demonstrates 3 points about the meanings of the Privileges or Immunities Clause in Section 1 of the 14th Amendment. First, privileges and immunities were synonyms for rights. So they're not 2 separate things. They're the same thing. Okay, great. Second, both the state and federal governments had long recognized inalienable rights of their citizens. Third, Article 4, Section 2 of the Constitution protected traveling citizens against state discrimination with respect to fundamental rights of state citizenship. Yeah, great. That's super, super helpful. Thank you. 2 questions still remain, both provoked by the text similarity between Section 1s of the 14th Amendment and Article 4, Section 2. The first involves the nature of the rights at stake. Are privileges or immunities as citizens of the United States recognized by Section 1 the same as privileges and immunities of the citizens of the several states to which Article 4, Section 2 refers? Because the Constitution uses the Constitution in its main body talks about privileges and immunities. 14th Amendment talks about privileges or immunities. So are those the same thing, different things? Fair enough. The second involves restrictions imposed on the state. Does Section 1, like Article 4, Section 2, prohibit only discrimination with respect to certain rights if the state chooses to recognize them, or does it require the state to recognize those rights? I address each in turn. Fine. Yeah, Jimmy, I'll just do this in full screen. Jimmy Keel in chat asked, why doesn't this cover bladed weapons? It does. It does. It covers all things that would be arms within the meaning of the Second Amendment. The Second Amendment protects the right to keep and bear arms. So the question is, what is an arm? Now, a lot of time, I will talk about this using firearms because in modern context, that's usually what we're talking about. So sometimes I'll use firearms as a shorthand. But yes, it protects all kinds of arms, whatever those would be within the meaning of the word arms of the Second Amendment, which would extend to bladed weapons as well. So yes, when I talk about firearms, I'm using it as shorthand because, in contemporary legal jurisprudence, like that's 90+% of what we're usually talking about is where this is coming up. But yes, you would be able to bring a Second Amendment challenge over knife rights, and people do, and sometimes successfully. There's an entire organization called Knife Rights that does that specifically for this issue. So yes, the bladed weapons issue is just as relevant on the Second Amendment. It's just that, at least from my frame, we normally are talking about firearms, so we just use it as shorthand. But it would protect anything. It would protect anything that is within the meaning of arms, as it would be understood when it was written. Because we're adopting all that stuff. So not a contemporary understanding, but the understanding at the time. That's what we're talking about. So that would include bladed weapons, yes. The court in Dred Scott did not distinguish between privileges and immunities of citizens in the United States and citizens in several states, instead referring to the rights of citizens generally. It did, however, give examples of what rights the citizens were: the constitutionally enumerated rights of the full liberty of speech and the right to keep and carry arms. Yeah. Interpretations of the 14th Amendment in the period immediately following its ratification helped to establish a public understanding of the text at the time of the adoption. This is how you do this in originalism land. You can look to anything that's contemporary, and you can look to things that are either more before or immediately after, right? Because things that happen immediately after might also be contextually relevant. So that's pretty common. Some of these interpretations come from the members of Congress. During the 1871 debate of the bill to enforce the 14th Amendment, Representative Henry Dawes listed the Constitution's first 8 amendments, including the right to keep and bear arms, before explaining that after the Civil War, the country gave the most grand of all these rights, privileges, and immunities by one single amendment to the 4 million American citizens who were formerly slaves. That was the idea, but yeah, things went awry. Even opponents of the 14th Amendment's enforcement legislation acknowledge that privileges or immunities protect constitutionally enumerated rights. Legislation passed in furtherance of the 14th Amendment demonstrates this even more clearly. For example, Congress enacted the Civil Rights Act of 1871, which is pretty contemporaneous with the 14th Amendment, yes, which was titled in pertinent part an act to enforce the provisions of the 14th Amendment of the Constitution, and which is codified in the still existing 42 U.S.C. 1983, a statute we know and love very much here on the channel. So yes, that's where it comes from. It comes from 1871. So there you go. The statute prohibits state officials from depriving citizens of any rights, privileges, or immunities secured by the Constitution. Although the judiciary ignored this provision for decades after its enactment, and arguably much of the Bill of Rights, but let's look past that, unremarkable in light of the text as protecting the Constitution's enumerated rights. This evidence plainly shows that ratifying public understood privileges or immunities to protect constitutionally enumerated rights, including the right to keep and bear arms. As the court demonstrates, there can be no doubt Section 1 was understood to enforce the Second Amendment right against the states. In my view, this is because the right to keep and bear arms was understood to be a privilege of American citizenship guaranteed by the Privileges or Immunities Clause, which makes, again, perfect sense. The Federal Bill of Rights applies to the federal government, so it was part of being a federal citizen. And the whole point of the first part of the 14th Amendment was to bring all those rights applicable against the states. So that was the entire point. And then, things went awry. So we had to invent substantive due process to do essentially the same thing. And, Justice Thomas can write, as you might be seeing. He can write. He's going through a lot of history, going through it in detail. If you want the whole historical lesson, there you go. So Justice Thomas is about to return to the Slaughterhouse cases and where it went all wrong to talk about that a little bit more in detail. So let's read what he has to say about this. The inquiry he begins with is the Slaughterhouse cases. There, the court upheld the Louisiana statute granting a monopoly on livestock butchering in and around the city of New Orleans to a newly incorporated company. Butchers excluded by the monopoly sued, claiming the statute violated the Privileges or Immunities Clause because it interfered with their right to pursue and exercise trade. This court rejected the claim, holding the asserted right was not a privilege or immunity of citizenship, but one governed by states alone. Which probably makes sense, right? The ability to engage in trade is typically regulated by states. And, there might be something built into the federal constitution, but it's not immediately obvious that there's, anything in the federal government that's this falls into the scope of police powers, which is the general regulatory authority of a state. the type of businesses they have and how they regulate them are principally state action. So yes, it is probably not a privilege or immunity. That makes sense. The court held privileges or immunities protected only the rights of federal citizenship, which owe their character to the federal government, its national character, and constitutional laws. It did not protect any of the rights of state citizenship. In other words, the courts defined these two sets of rights as mutually exclusive. Well, I don't know that's quite right as mutually exclusive because they're not quite mutually exclusive, but yes, they are different for sure. So your federal rights and your state rights are different. And the whole point of the 14th Amendment is to impose the federal rights on the states. That's the goal. Not to impose state rights on the federal government. That doesn't even make sense. And not to impose one state's rights on another state's, because that would interfere with a sister state. The whole point is to create these federal rights and ensure they're guaranteed. After separating the two sets of rights, the court defined the rights of state citizenship as embracing nearly every civil right for the establishment and protection of which organized government is instated. That is all the rights listed in Corfield. Okay. That left very few rights of federal citizenship for the Privileges or Immunities Clause to protect. Okay. The court suggested a handful of possibilities, such as the right of free access to federal seaports, on protection of the federal government while traveling on the high seas, and even two rights listed in the Constitution, and the privilege and the right to peacefully assemble, and the privilege of the writ of habeas corpus. But the decision to interpret the rights of state and federal citizenship as mutually exclusive led this court in future cases to conclude that constitutionally enumerated rights were excluded from the Privileges or Immunities Clause scope. See, for example, Crushing. That's where things went off the rails. I reject that understanding, and so do I. There were no reason to interpret the Privileges or Immunities Clause as putting the court to the extreme choice of interpreting privileges and immunities of federal citizenship to mean either all those rights or almost none of the rights. The record is scant on the public understanding of the clause to make the federal government a perpetual censor upon all legislation of the states, as well as the Slaughterhouse majority feared. That's fair. So the Slaughterhouse majority was concerned, and rightfully so, about it being too restraining on state action. It should only be what it says, right? And if it imposed on every state the rights of every other state, that would be that would be too much, right? Because that's interference. So it is only the federal rights. That makes sense. And almost all the rights that you have are as a matter of state law, which totally makes sense. It totally makes sense because almost all of them are, because the state is the one with police power. So almost all the rights you have are a matter of state law. So your right to engage in trades, generally, your rights to own property, generally, and the conditions of it and how it's governed and all that crap is state law, right? So state law is pretty much everything. Totally makes sense. But there are a few notable exceptions. For example, the entirety of the Bill of Rights. That should have come along for the ride. That makes sense too. So you don't necessarily have a right of trade argument because that's whatever the interest that is. That's not one of the Bill of Rights. Doesn't seem obvious, at least. So, no, it's not a privilege or immunity. That makes sense. And they're concerned about overreach, but all the Bill of Rights. That's cool. The better view, in light of the states and federal government's shared history in recognizing certain inalienable rights in their citizens, is that privileges and immunities of state and federal citizens overlap. This is not to say privileges and immunities of state and federal citizenship are the same. No, they're not. At the time of the 14th Amendment, states performed many more functions than the federal government. Yeah, and arguably still do, depending on your point of view. And it's unlikely that simply referring to privileges or immunities, framers meant to transfer every right mentioned in Cornfield to congressional oversight. No, that's definitely true. That's definitely true. As discussed, the privileges and immunities were understood only synonymous with rights. It is their attachment to a particular group that gave them content, and text and history recounted here indicate the rights of citizens were not perfectly identical to the rights of citizens in the several states. Fair enough, they're not. There's a different group of things. So your right as a citizen in one of the several states is not the issue. Your right is the federal citizenship rights, which presumably means the entirety of the Bill of Rights, which is exactly what we've wound up doing. So, okay. Because the privileges and immunities of American citizenship includes rights enumerated in the Constitution, they overlap at least with some extent with the privileges and immunities traditionally recognized in citizens in several states. Yeah, fair enough, and that's a fair point. So some of the states did recognize these rights as a matter of state law. That's cool, no problem. And most state constitutions to this day have analogs to most of the federal Bill of Rights in their state constitution. And to this day, you can go argue about the respective meanings of those separately. And occasionally, a state Supreme Court will say, well, our language, even if it's the exact same language in the federal government, right? Because this is a state law interpretation. So even if it's literally the exact same language in both the federal government and state government language, occasionally you'll see a state Supreme Court that says, even though our language says exactly the same thing, it means more than the federal government does. And you can do that if you're a state because the Constitution sets a floor, not a ceiling. So you can always say, well, our language means more than the federal government. I mean, the federal government interprets their language, but we interpret it differently in our state law. You can do that as long as you're giving more. So the idea that there's, a freedom of speech guarantee in a particular state, well, of course there is. There's almost in all of them. So the states recognize the same rights the federal government do. So there might be some overlap there, but that's not really the question. So it's not the issue. They're different sovereigns. They're different sovereigns and they mean different things. And it's in the same exact way that if the state of, just to pull out two examples off the top of my head, but if the state of Virginia and the state of West Virginia both have a freedom of speech clause in their respective constitution, which I assume they do, it may not mean the same thing in those respective states. The freedom of speech might mean something different in Virginia than it does in West Virginia. And it might be a little bit broader in one of those states than the other, because again, both of them can interpret them broader within their respective state laws. So again, even if the language is exactly the same in the federal government and exactly the same in both Virginia and West Virginia, this is a hypothetical, they can mean different things as a matter of state law interpretation, because each state is sovereign as to what its state law means. So they can interpret the same provision differently. That makes sense. So this is, but so there might be some overlap or some not. That's not the issue. The question is, what did the federal government right encompass? That's the issue. That's what we're trying to determine. What is the federal right? So what your state rights are to this analysis irrelevant. And I agree, it is irrelevant. So your freedom of speech rights, as they might exist under the Virginia Constitution or Virginia's Bill of Rights or Virginia law, whatever that might be, right? Your freedom of speech interests there are super, super interesting, but not relevant to the federal constitutional interest and what it's trying to do. The interest is, what does the federal government say and what's imposing on Virginia? So whatever Virginia wants to do, is neither here nor there. Makes total sense to me. Finding the impediments to returning to the original meaning overstated, and I'm not sure I agree with that either. There's a little bit of impediments, but Justice Thomas thinks it's not that big a deal. I think it's a bigger deal. It's kind of a bigger deal. So the pragmatic concerns in me are a little bit hesitant. So he thinks it's not that big a deal. I think it's a little bit of a deal. But he says it's not that big a deal, and he rejects Slaughterhouse insofar as it precludes any overlap between privileges and immunities of state and federal citizenship. Well, I also agree to that much for sure. I next proceed to stare decisis question regarding the precedent. I agree with the court. The Second Amendment is fully applicable to the states. I do so because the right to keep and bear arms is guaranteed by the 14th Amendment as a privilege of American citizenship. So that is our end of the coverage of Justice Thomas's concurring opinion in McDonald versus City of Chicago. And this was very interesting, and thanks to the person who gave the $20 super chat to support this and encouraged me to do it, and it was very insightful. It goes into some of the foundational theories of originalism, talks a lot about originalism, and we skipped quite a bit of the opinion because it's quite lengthy, a lot of history going into exactly showing some of the history and backgrounds of what various languages, showing the originalist interpretation, actually proving it. Really, really insightful stuff. So if you're really interested in the history of what the right to keep and bear arms meant in an originalist understanding, this is a pretty good place to read, because it goes through a pretty lengthy recitation of what various language was understood to mean. So it's pretty insightful. And goes through some of the foundational theories on privileges or immunities clause of the 14th Amendment and what it was or was not meant to do. And then says the Supreme Court has not been pure, which, it hasn't been. And it goes into why it makes more sense in Section 1 of the 14th Amendment rather than what we've done through this invented idea of substantive due process. Now, as I was saying throughout the video, I'm not quite sure how much it really matters in the end, because it's not clear to me that there would be much difference in going through this process at this point. But he's pointing out that there was an error made basically 140 years ago that's been perpetuated, and that's where we are. So that is our end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.